Hey folks, thanks for joining me today. I want to say thank you very much for continuing to support this podcast channel. But today's guest is James M. Porfido, and he is a longtime prosecuting and defense attorney, so he is also an author. He wrote a book called Unequal Justice: The Search for Truth to Balance the Scales. So obviously we're going to talk about law. Now, I don't know much about law. I'm not going to say that I've been in trouble, nor that I haven't been in trouble, but it's quite interesting to hear some of his stories. And I asked him questions, which might sound dumb to some folks out there, but it's just out of curiosity. So I hope you enjoy this podcast, and please remember to like, share, and subscribe. And once again, thank you very much for continuing to support this channel. So let's go ahead and get right into it. Oh, let me remind you, if you are a pet owner, please be a responsible pet owner and have your pets spayed or neutered.
I started out as a prosecutor and worked many years and rose through the ranks in the prosecutor's office, and I ultimately was the head of vehicular homicide and sex crimes and child abuse and handled a lot of high-profile cases. And then ultimately I became a defense attorney, and there was one particular case that happened that kind of made me shift directions. And but I've been doing this for about 35 years, and people say, why did you write the book? And I say, I really didn't write the book. The people, the cases really wrote the book. I mean, it was really about my dealings and my experiences with those people.
Before we really dive really deep into it, I want to ask you up front, the defendant versus the prosecutor type of situation, who has it more difficult when it comes to that in court cases?
Sure.
Or does it matter, or does it depend on the situation?
Yeah, if you asked me that probably 30 years ago, I would tell you, I would say as a prosecutor it was very challenging and very difficult. But then later on, having made the transition from a prosecutor to a defense attorney, I would say it was much more difficult being a defense attorney, because you don't have the resources and you don't have the advantages, and quite frankly, when you're representing someone that's accused of a crime, it is, you said earlier, innocent until proven guilty. That may be the concept in our principles of law regarding the Constitution, but I don't think that people really think that. They think that when someone's arrested, there's something there. There's obviously enough there to convict that person, and they must be guilty. So as a defense attorney, I often felt that I had the burden, although it is the state's burden of proof to prove beyond a reasonable doubt that an individual is guilty of the crimes that they're accused of. I felt as a defense attorney that I took on that responsibility to disprove that they committed the crime, or that there wasn't ample evidence to satisfy the burden of proof that they committed the crime.
I guess, you hear stories from both sides of the, I don't know if I should say aisle, but from both sides, where the person who is being prosecuted says, I'm innocent, I'm innocent, I'm innocent. And then, of course, on the prosecutor saying guilty, guilty, guilty. And I would imagine both, whether you're prosecuting or defense attorney, it's got to be difficult coming up with the evidence beyond a reasonable doubt type of situation for proving your innocence or to prove the person's guilt. Is there, on the defense side, is there a process that you generally go through, or an attorney generally goes through to prove this person's innocence?
Well, that's a great question, because I always felt that my thinking process never changed. I always thought like a prosecutor. So I would always think, well, how much evidence will I need to have this person convicted? How much evidence needs to be presented to satisfy that burden of proof? As a defense attorney, I looked at it quite frankly the same way. If I were the prosecutor in the case, how would I prove that case, and what evidence would I need? And many times I felt that made me a very effective defense attorney, because I could look at it through the state's eye, through that prism, and say they don't have the evidence to support the charges, or they missed collecting evidence. Physical evidence was not retrieved at the scene. They should have interviewed different witnesses, and they didn't. So I would look at it very analytically, very critically, from that prism as a prosecutor, even though I was the defense attorney. So I would approach the prosecutor with that review that I've had, or in terms of the discoverable materials, the evidence, and say, look, there are going to be some problems in your case. Either my person didn't commit that offense and you can't prove it, and they were just in the wrong place at the wrong time, or the evidence that you have does not support the elements of the offense to convict this person. And that would sometimes make for a better plea negotiation. And a lot of cases do get resolved by way of plea bargaining. I know a lot of people are offended by the idea or the concept of plea bargaining, but quite frankly, our system could not function without that. There's no way every case could go to trial.
Yeah, and forgive me for jumping around a little bit and asking before we really dive deep into your book, but I'm thinking about some questions that where I hear people talk about, and you mentioned discoverables or discoveries. Can you explain to us how that works in a process from either side?
Well, in the state system, at least in New Jersey, and I think most states are pretty much the same, is that the prosecutor has an obligation to turn over evidence, discovery, police reports, fingerprint analysis, whatever it may be, photographs, videotapes, interviews of witnesses of your client. If your client is interviewed by the police and they don't invoke their Fifth Amendment right and say they want to not say anything and they want to be represented by counsel, which they have an absolute right to do, and certainly I would have advised that individual, if they had come to me beforehand, I would say don't say anything because it's not going to help your situation. But in terms of the discovery, the prosecutor, the state, has the obligation to furnish it to the defense before a decision is made. That's in the state system. In the federal system, it's very different. The discoverable materials are turned over very late in the game. In the state system, it's very early, so that you can have meaningful discussions with your client about whether or not the state can prove the case and whether or not you should be trying to negotiate a plea, or this is a case that we need to go to trial on. If the evidence isn't there, I might be encouraging them, look, this is a case that has to be tried. And I think you have a case that's winnable.
So why is there that difference between the state and the federal level, given the discoveries or discoverables early on or later on?
Right.
Is it to mess things up, so to speak, to drag things out, or what is that?
Well, it's just a different system, and I've done federal cases over the years, but not nearly compared to state. I mean, that's really where I was in state court. I would say 90% of the time, 95% of the time. So the state system is very different, because the rules are different. We have state rules of court, and then we have federal rules of court, and the federal civil procedure determines the turnover of the discovery. So it is later in the process, and they have the ability to do that. And I think it's an advantage that a U.S. attorney has, a very strong advantage in a federal case, is turning over that discovery late in the game versus right up front.
Do you have any examples that you could give us from your book as far as situations that involved discoveries where whether it helped your case, your side,
Sure.
or where it may have hindered?
Yeah, I talked earlier about the case that kind of led me leaving the prosecutor's office and becoming a defense attorney, and that's a case involving a vehicular homicide, and it involved the death of a mother of three. She was driving with her three children in the car, and this individual was the defendant in the case, was driving. He was more than 2 times the legal limit of intoxication. At that time in New Jersey, it was a 0.10. He was about a 0.25. So he was very intoxicated, and he was driving on the shoulder on the median. He was going through red lights. He was doing more than 85 miles an hour, and ultimately he impacted with this mom. That's a case where there was ample evidence. Many people were calling saying they had observed the driving conduct of this individual, and they knew that at some point he was going to be impacting, crashing into someone and killing someone. And it was a very tragic case. Ultimately, the mom was medevaced from the scene and put on life support. And I got to know the husband. And through my involvement with the husband, I explained the laws in New Jersey that existed at that time in 1994. And I explained that. And he was obviously upset because in New Jersey, if under the death by auto laws, that individual could face a maximum of 270 days in county jail if he had no prior criminal history. Now, trying to explain that to someone who tragically lost their wife, it's nearly impossible. And he said the result is the same if it's a gun, a knife, a vehicle. It's no different. It's murder. And I said, well, it's without an intent. So under the vehicular homicide statute, it's conscious disregard, a reckless indifference for the value of human life, versus a purposeful knowing conduct where someone went out premeditated, going to, with a plan and a purpose to commit a crime or a murder. So I explained that to him. He was actually instrumental in getting the laws, single-handedly got the laws in New Jersey changed under vehicular homicide, where now it's mandatory that you serve at least 3 years in state prison if you are convicted. In that particular case, there was overwhelming evidence of this defendant driver's conduct, and I was prosecuting the case, and it was presented to a jury, and he was tried for aggravated manslaughter. Just to give the listeners an idea, it's the same thing as a homicide, but without a purposeful intent. It's with a reckless intent, and he was convicted, and he was sentenced to 20 years, 10 years without parole in state prison. And I got to know the husband, and he had started a foundation speaking to young students, high school students, about the dangers of drinking and driving and drug and alcohol awareness, and in particular this case, talking about the case and the loss of his wife and her life, and how he became involved in this. Well, tragically, he himself was jogging near the site where his wife was killed, and he was struck by a car and killed. So I made the decision to leave the prosecutor's office, and I became, the face for the foundation. I took on his role as the speaker, and I did a number of presentations. I talk about it in the book. I spoke to about 75,000 high school students over a period of 2 years in New Jersey about the case in particular, about the laws, the change in the laws, and also about the dangers of drinking and driving and making good decisions. As you're getting your license, you don't think of these things, 1 drink, 2 drinks, and now marijuana, of course, has become legal, and that is going to be the next problem that we face or encounter as a society. But that particular case, there was overwhelming evidence, and I was turning it over to the defense attorney in that case. I was in a different role, and I was presenting, and we had many, many witnesses. In fact, we didn't even call all of the witnesses because we had so much evidence of his reckless conduct. But I respected the obligation. I understood the obligation that I had, and I had to comply with that obligation, which is to turn over that discovery, even though we may not have used it all.
Now, I'm going to ask you on a personal for yourself and for other attorneys out there. How difficult is it, and how does it get to your psyche if you are a defense attorney, or maybe even a prosecuting attorney, where you have this gut feeling that the person is innocent, but you have to bring forth evidence to prove their guilt? It's a
good point, because prosecutors' job, their role is not to convict, it is to do justice. And in the case where they believe that they have the wrong person or there isn't evidence to support the charge, their responsibility is to come forward and say, hey, I don't have it here. Perhaps it means dismissing the case against your client. Perhaps it means negotiating a very favorable plea deal to the defendant in the case. And that does happen. It does happen.
Okay.
But, it is challenging for sure. Trying to go to bed at night as a defense attorney, I think, is even more like, as a prosecutor, you have a responsibility to do. You have a job. You're paid by the taxpayers. You represent the people, the state. And the situation in the courtroom, the way the positioning in the courtroom represents that. The counsel tables are situated so that the prosecutor's next to the jury box. the defense attorney is over on the other side. So that's kind of the throwback to our old English common law roots. But I felt really as a prosecutor that I had a lot of an advantage, that I could, I was representing the people. I felt like, hey, you guys have to believe me because you pay me, and I'm here to do a job, and I believe in this job. And, ultimately, as I got more comfortable trying cases, I could, look jurors in the eyes and speak to them, one-on-one, and be comfortable and feel like, hey, there was a connection there. There may not have been, maybe it was just in my mind, but I felt like that connection was, hey, these people, they've got to be happy that I'm working on this side. If I'm doing a good job, they got to say, hey, we like this guy and we're happy that he's representing us. Now, as a defense attorney, it's very different. You walk into the courtroom and your role and your responsibility is to represent your client and to protect their constitutional rights. Make sure they have a fair trial, a speedy trial. They have a right to confront their accusers. They have a right to good, competent, capable counsel. These are all, rights that are in our amendments, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment of our Constitution, the Fourth Amendment against unreasonable searches and seizures, the Fifth Amendment as it pertains to self-incrimination, the Sixth Amendment as it pertains to the right to effective counsel, and the right to confront the witnesses that are accusing you of the crime, the witnesses against you. So these are really important responsibilities that a defense attorney has. And, the feeling is when you walk in the courtroom and you're representing someone's accused of a crime, that automatically the deck is somewhat stacked against you. And I experienced that later on and felt it very much that even the judges were aligned with the prosecutor in many cases. The judges, as much as their responsibility is to be neutral, unbiased, detached, impartial, I found that they were swayed more towards the prosecution, and many times it was an unfair fight. It was 2 against 1.
Can you speculate on as to why you think that is? Could it? Yeah, I'm gonna pull this out, as everybody does. Race, gender, ideology, all those things, can it play into it because we are all humans, and then we say we're not going to take that into any consideration of innocence or guilt, but we still somehow do?
Chuck, I would say it's all of the above. Everything.
Okay.
Because you can't separate out people's opinions and beliefs just because they walk into a courtroom. Even in jury selection, in the jury selection process, when you're what we call voir direing prospective jurors, you're asking them questions and you're accepting their answers, that they can be fair and impartial. There's nothing about the case that's going to lead them to be anything but fair and impartial. They can listen to the evidence. You're asking them basically to be a blank slate, to walk into the courtroom and forget about their life experience, forget about everything. And I think that's impossible. And I think it's impossible for judges to do as well. I think that if a judge doesn't like a particular case, perhaps it's gotten some notoriety, doesn't like a particular defendant for some reason, the accused, and it does happen, maybe they're leaning more towards the prosecution. And again, they have a role and a responsibility. And I experienced this later on in my career when we changed the Criminal Justice Act in New Jersey. We got rid of monetary cash bails. So what was substituted was an algorithm, a mathematical calculation to determine if somebody should stay in or be released. And
really?
The score came up, it was a computer-generated score done through an independent probation officer given to the judge. It's called a PSA.
You're absolutely serious about this.
Yeah. It's called a public safety assessment, a PSA score. And the judge could simply look at the score and say, given the numbers that I see here, your client is a risk to commit another offense. Your client is a risk if they're released. they have a background or a history that I don't particularly think that leads them to being released into the community, or this is an offense they're charged with where there's a likelihood they could get convicted and spend a lot of time in jail. There's significant penalties, so that person would stay in jail. And I've experienced that later on in my career. I had 7 people in jail at one time. And it was very challenging and very difficult because I did not believe that those people belonged in jail just to wait for their day in court. You know, I felt that they were being unfairly treated. In at least 3 of those situations, I went to the appellate courts to have the judge's decisions reviewed, to say the judge had abused their discretion in holding this person in custody, waiting for their trial date. And in each instance, the appellate courts upheld the decision of the trial court judge. So I was 0 for 3 on those appeals. And one case in particular was really, I'll say mind-boggling, because it was a young man charged with a date rape, and he was about the same age as my son, and he was in college, and he had known this girl, and she had slept over the house, and claimed that she had too much to drink and really didn't give consent. She didn't consent to the sexual act. So, and he said, no, I thought this is what was going on. He said, you know, was I confused? Maybe I was confused, but I don't think she was that intoxicated that she couldn't say no. And the case went on and on and on. And I said to him, sadly, I've done everything I can do to try to get you out. The judge is just not inclined to release you. And I talk about this case in the book, actually, because it was really, really challenging. I even went to the appellate courts. I told the family, I said, this is a very difficult case. You know, it's a he said, she said. There's no evidence. It's his word against her word. And I always felt that this woman, this victim, and I was never about victim bashing. In fact, I talk about my representation of crime victims in the book. I represented victims in many high-profile cases. It wasn't about bashing the victim, but I felt there was something inherently off with her credibility. And the investigation was somewhat tainted because it was flawed in that the detectives had interviewed her with a school counselor in the room. And I said, that's not allowed. They should have not had that woman in the room with them when they interviewed this woman. So from the beginning, I knew the case was flawed, but I could not get a judge to agree with me. So I went through the process, and I told this poor young man, he would call me every night. I felt like his counselor. And I just said, hang in there, your day will come. And I found out the young woman started an OnlyFans site where she was exposing herself for money. I tried to present that to the prosecutor and say, you know, she's not really, and I'm not about bashing her character or what she does, but this is going to go to her credibility. She didn't want to hear anything about it. He remained in jail. I had a meeting with his family, and I said, look, the only thing we can do is wait for the day at trial, you know, to confront this young woman and present the evidence. Well, they said, look, we think we need to get another attorney. And I said, I respect that. That's fine. I've done everything I can do, and I've tried my hardest with passion, with, you know, zealously trying to represent my client and aggressively trying to present his position. So they hired another attorney for a lot more money than I was charging them, which has nothing to do with where I'm going. But the young woman became an escort in Florida, the one that had accused him of the rape. And it turns out that she was involved with a John, an escort, and she tried to extort money from him because she found out he was married. And he attacked her, and she stabbed him. And that was about 2 years later. He sat in jail. A year and a half later, he sat in jail that whole time, and the charges were dismissed. Ultimately, they were dismissed. Sadly. And I felt terrible for this young man, and I think he went back to college after that. But if you can imagine spending a year and a half in jail waiting for your day in court, and it all resting on this individual, this victim, who was going to come forward and provide the evidence to the jury that he had, quote unquote, raped her, sexually assaulted her. And we didn't believe that from the beginning.
With that being said, in that situation, and just brings me to think about some of the people that are accused, but these things that had happened years and years and years and years ago, but then it brought up. It just seems, I don't want to already pick sides without, anything in front of me being presented, but oftentimes it seems like it's an unfair situation or an unfair advantage for the prosecutor, because say that something like this in this situation, maybe it was an incident from 10 years ago, and then who knows if over the course of 10 years they get married and they have kids and they see a TV show and then they go, oh, maybe I was in that situation, or I can't remember, but you know what, I'm going to do something about it. So it just seems, again, I don't want to come out and say it's unfair on every situation, but it seems greatly unfair in many situations.
Those are particularly challenging cases, and I have represented Catholic priests on the defense side and even prosecuted one at one point. So I had some familiarity with that. And in those cases, where you have altar boys later on in life come forward and make allegations that they were sexually molested or abused, those are particularly challenging because there may not be any physical evidence. The evidence is long gone. It really comes down to their word. And many times they're encouraged by attorneys to file civil lawsuits against the church or the diocese. And then it becomes an issue of, hey, is it about punishment for the bad acts of this person or the criminal acts of this person, or is it about you being compensated? And there were some huge settlements made by the Catholic Church, and it was really a real cloud over the church for some time. And I represented a priest charged with a sexual assault of a young woman right around the time the movie Spotlight had come out with Mark Ruffalo. It was about the sexual abuse of young men in the Boston diocese. And it was very challenging, and I told the priest that I represented that it was going to be very, very difficult. And we did an unbelievable job in the case. I think I called 23 witnesses. The prosecutor only called like 3 or 4. And there were many, many people that came forward to speak well about this priest, and even so much so to where the prosecutor originally investigating the case said they were going to overcharge the priest to make sure that he pled guilty. They were going to charge him with an offense that carried some significant time. And I learned that through the diocesan attorney. He represented the church. He told me that, and he actually had an email from the prosecutor somewhat memorializing that conversation, which was really, in my opinion, was unethical. And, if you had the evidence to support the charge, that's one thing, but to threaten that, to force someone to plead guilty so that they couldn't exercise their constitutional rights, that was something else. So to fast forward, we did try the case, and ultimately the jury found him not guilty, but they did find him guilty of the one offense that the prosecutor had said he would overcharge him for, which was luring. Now, in my mind, luring, it's a charge where, if someone were to pull up to a young child in a car and try to entice them to get into the car to commit an act or a criminal act against that child, that's an act of luring. Well, the act of luring in this case was simply him walking from the church across the courtyard to the rectory and having her go to his sleeping quarters, which was in the rectory. He had his own living room, I guess, where he also had a bed. he invited her in. He became friends with this girl over a period of time. She was about 15 years old, and I was the second attorney in the case, and it was tried 6 years later. So I felt like we had some built-in, I'll say, I don't want to say defenses, but I'll say an advantage, because this young woman who was 15 was going to be 21 when we went to trial. And obviously she wouldn't look the same from a 15-year-old as a 21-year-old. The irony is I called in the book the victim that never aged, because when she came to court, she didn't look like a 21-year-old. She looked like a 15-year-old. And as soon as she walked into the courtroom, I think that we kind of lost the case, because I saw that the jury was already, in their minds, they felt like it was a priest, it was a sexual case. That movie had just come out. We really had the deck stacked against us. But I felt like we won the case on many levels. But ultimately the jury did convict him of that one charge of luring, and he was sentenced to 6 years in New Jersey State Prison and 3 years without parole.
I do have a question about luring, baiting, and things like that. But before we go there, I was wondering if you could let everybody know where they could find your book and the information. Once again, it's
Unequal Justice, The Search for Truth to Balance the Scales. And it's available on Amazon.com, Barnes & Noble. I'm trying to get it into brick and mortar stores. I've done some signings of the book. I have a book signing coming up at a local bookstore. I also have a website that was created by the publishing company, unequal-justice.com. And there's information about the book and about me. And certainly they can find me easy enough. All I have to do is search my name, and they'll find me very easily. I'm still working as an attorney. I'm affiliated with a firm. I'm of counsel in the criminal section of our firm. We have about 50 attorneys. And
okay.
Yeah, so I'm easy to find, and certainly the book is easy to spot too.
I'll remind folks, when you're looking for Jim, it's actually under the author, his name, James M. as in Mark.
Mark, Matthew.
But James M. Porfido. Is that correct?
That's correct. You got it.
Okay. So my question is, and since you're still counsel, I don't know if you can actually really answer this, but as far as like luring and baiting and things like that go, I had a conversation with someone and they said, you know what, I want to catch these thieves. I think what I'm going to do is, I know a neighborhood where there's a lot of crime, and I'm going to put my handgun on my seat in my car and leave the door unlocked so I could catch them. And I said, well, wouldn't that be considered like baiting somebody, because you know the area is high crime and you're leaving a handgun plain sight with the door open? Can that be considered a bait to catch, or like a lure, or is that a sticky situation?
Well, that, if it were a law enforcement trying to entice someone to commit a crime, that is entrapment, and it's not allowed. But I talk about one of the investigative tools in the book that I found later on in my career, particularly in sex cases. It was really used quite a bit. It was a tool that was utilized by the prosecution. They would do what's called a consensual overhear. Now, normally you would have to get authority from the court to do like a wiretap, to listen in on a phone conversation. In a consensual, it's very different. A consensual overhear is if I'm accusing you of, say, inappropriate sexual conduct, I call you up and I say, hey, you know what happened last night? You shouldn't have done that. I said no, and you did it anyway. Now, if that person on the other end says, yeah, I know, I'm sorry about that, I shouldn't have done it, and I know you did say no, that's it. They're done. Mm-hmm. That because they don't need any authority of the court. They just need authority of the prosecutor, and usually there's a police officer right there instructing them what questions to ask. And I saw that happening more and more and more. In fact, the case I talked about earlier, that happened in that case where the young woman said, "Hey, I was so drunk and you shouldn't have done this." And he said, "Hey, I didn't think you were that drunk. I thought this was something that was going on between the two of us." But it does happen. But to get to your example, that's interesting. I would say that, first of all, it's very dangerous to leave a gun in a car. Obviously someone would approach the car and look to steal the gun. I think if that's the idea, is to get them to go into the car and steal the gun. Then you need to conduct some form of a citizen's arrest, and that's a dangerous situation. Now, if the person were to say to the police, "Hey, I'm going to do this, I want you to be ready to arrest that person," it is a form of entrapment, because now you have the police authority behind it. So once you have the authority of the state behind the action, it becomes impermissible or unconstitutional or challenging.
Okay. Yeah, their whole plan was, I'm going to put a tracker in this, and then because I want to catch the people who steal things, and then I'm going to go tell the police I know where this, my firearm is, because I left it on my seat on purpose, and I put a tracker in there to track them. So.
Yeah, the example you just made, it's interesting. I had a case similar to that where a young man had purchased an investment property. He was fixing it up to sell it, and he had hired a dubious contractor, I'll say, somebody with a very checkered past, and he was paying him a lot of money to, get this house up to snuff, so to speak, to sell. And he was basically taking the money. He wasn't doing the work. So my client became very upset by this individual doing this, and ultimately he put a gun that he had a lawful right to own and possess. However, he did not have a right to do what he did, which was he went to the location where this contractor lived. He had a T-shirt over the gun. He called the contractor over and he said, "Listen, if you don't get to my house and finish, this is what's going to happen to you." And he lifted the shirt and made a threat to him that, this is going to happen to you and I'm going to use this. Well, that went to trial, believe it or not, because he had no prior criminal history, and we were able to gather all the financial records associated with the money that he had paid this contractor. And he was a likable person, and the jury ultimately, and the contractor was not a very good witness. He actually did not help himself at all, nor did I guess it was his fiancée who was present, and claimed it looked like a purple gun. And the jury just didn't believe it at all, except my client had admitted in an interview with the police that he had gone to the location with the gun, which he wasn't permitted to do. In New Jersey, it was prohibited under the law. So he was convicted of unlawfully transporting the weapon, and ultimately was sentenced and did some time for that. Wow. But the jury found him not guilty of all the other charges, the threatening and the act of terroristic threats, which he was charged with. There were several other charges that he was found not guilty of, but was found guilty of that one charge.
Wow, that seems like in some sort of situations that would be very unfortunate, because you're there because you think you're being charged with something, and then the prosecuting attorney maybe knowingly goes, "You know what? They got us on that, but I could dig them up on something else that he or she did."
Yeah, and if they can draw a connection to it, and if there's evidence to support that, by all means, why not? Yeah. Like, as a prosecutor, you want to leverage all the advantages you have. I mean, look, I was a prosecutor too. In my former life, and the role of the prosecutor is, if you can convince the defense attorney that there's ample evidence to support the charge, then you can avoid a trial situation, and that person's going to plead guilty.
That leads me to say this, that what we see and what we hear isn't always true. And like you said, just because you think it's not fair or not right, you don't know the situation. And as you said, the prosecuting attorney's job is to do whatever they can at their disposal to prove that guilt of the person, as long as it correlates with what they're prosecuting for. Then,
Well, I look at their responsibility as the search for justice, really more than anything.
okay,
Their job is not to convict that person, but to look and say, is justice going to be served if this person is convicted? And I talk about that. As a young prosecutor, I had to think very, long and hard. Do I have ample evidence to support the charge against this individual? Is this a case that's warranted prosecuting? As a representative of the people or the taxpayers, is it warranted? Should I be going the distance with the case through the court proceedings? Because let's face it, taxpayers are paying my salary. Is this something that they would say, yeah, we think you should be doing that?
it leads me to think to myself, what is justice? It's how's the definition of might be simple, but it seems like there can be a lot of gray area.
Yeah, most definitely, and it does depend upon the cases. I don't think there's such a thing as justice if you've lost a loved one, if there's a tragedy, if a family member is murdered, or sexually abused as a child. I don't think there's really a definition of justice that fits in those situations. If it's a financial crime and someone's stealing money from you or property from you and it's returned to you, or you're compensated for the loss, well, there's always going to be the feeling that you were victimized. But if you've been made whole, that may be some sense of justice. So it does vary, and it depends upon the cases, but I don't think there's really a definition of justice if you've lost a loved one tragically, either in a vehicular homicide type situation or an actual murder case. I don't think there's ever a definition of justice that fits. And even a betrayal of trust, a husband or a spouse attacking the wife and disfiguring her, and I talk about that in one chapter in my book, that loss of trust and ultimately the end of that relationship. I don't know that there's ever going to be justice, even if the person is prosecuted, convicted, and sentenced to a significant period of time. I don't think that's ever going to restore that faith or trust in that individual, and certainly perhaps the marriage, the idea of being married to another person.
I just want to remind the folks once again, James M. Porfido, Unequal Justice is his book. I don't see your job, your career getting any easier, at least not in the short term of 4, 5, 10 years. I think I think you've got a lot of work ahead of you.
Well, the system
mainly because of that.
Well, the system, people say, well, Jim, you wrote the book and you talk about all these situations of unequal justice, or people that weren't treated fairly, or that you had to fight within the system to get your client justice in some sense. But I don't offer any solution. That's the sad part about it. It's not like I can say, hey, this is what we need to do. This is the answer to our problems, because I don't have that solution. I think it's inherent in the people that are involved in the system. The prosecutors, the defense attorneys, the judges. Those individuals all have to make a concerted effort to ensure that people's rights are protected. And I think everybody has their own role to play in that process. So it's very challenging and very difficult.
I'm going to put you on the spot, sort of, kind of, and then ask you, vigilantism, yes or no?
Well, definitely no. I just, because you can't take law into your own hands, and,
Yep.
something bad certainly will happen. And then you'll have to answer for your behavior. I know that people are frustrated because they feel like they've been victimized and they don't feel that they're being treated fairly, perhaps, or the system is not working for them. And it certainly does present a number of challenges and issues, but certainly vigilantism is not the answer. Acting out on aggression, it's never the answer, the solution to a problem. It only creates more problems.
Yeah, agreed. So you guys heard that. Don't take the law into your own hands. It's not safe to do, and it is not. It's not safe, and it's not the right thing to do. Like I said, you could get yourself into trouble. Jim, this has been great, and I look forward to. I haven't read your book, but I look forward to reading your book. Once again, it's called Unequal Justice by James M. Porfido. Jim, thanks for letting me know to stay out of trouble.
Oh, thank you, Chuck. Thank you for having me on. There was some good discussion, certainly some big topics to talk about, and certainly a lot to think about for sure.
Yes, definitely. Well, stay safe, my friend. Have a great afternoon, and yeah, you guys heard it. Just again, don't take the law into your own hands, and please. This book is not a book of fictional characters. It's your reaccountment of things that have happened.
Yeah, it's a bit of a memoir. It's about 35 years in law and all the detours along the way, because I certainly had an interesting career in law, representing crime victims, representing the accused, prosecuting, and being a TV legal analyst, and ultimately a law professor now. And so there's been a lot of different, directions I've gone in, and it's been interesting.
Yeah. Well, again, thanks, and I do look forward to reading the book.
Thank you so much, Chuck. It was a pleasure.